Welcome to this explainer. Today, we're totally uncovering the precise mechanics of how companies raise massive debt and, more importantly, how regulators keep those investors safe. We're diving deep into Chapter 4 of the Corporate Rulebook, the issue of debentures. If you've ever wondered how major corporations secure just huge amounts of capital without giving away a slice of ownership, well, you're in exactly the right place. Let's look at how these powerful financial instruments operate behind the scenes.
Okay, here is our roadmap for today. First, understanding debenture basics. Second, the regulatory framework. Third, investor protection mechanisms. And finally, the issue procedure.
Let's jump right into Part 1, Understanding Debenture Basics.
So, what exactly is a debenture? Ultimately, it's a formal, heavily regulated IOU from a company. It carries an absolute legal promise of repayment. According to corporate law, it's an instrument that creates or acknowledges a debt. When you hold one of these certificates, you hold concrete evidence of a company's indebtedness to you, and it's issued right under their official common seal. It really is the ultimate corporate promise.
Now, the really fascinating thing here is the trade-off between money and power. As a debenture holder, you get priority repayment and guaranteed interest, which sounds great, right? But under Section 71(2) of the Companies Act, you are strictly prohibited from having any voting rights. You're a creditor, not an owner. In exchange for giving up your voice at the general meetings, your fixed interest has to be paid, whether the company makes record profits or takes a massive loss.
When a company issues these, they can be secured or unsecured. Secured debentures are backed by physical assets. A legal charge is created on the company's property. Think of it like a mortgage on a house. If they fail to pay you back, those specific assets can literally be sold off to recover your money. Unsecured debentures, on the other hand, don't have that physical safety net. They're based purely on trust, though they are still perfectly legal under the Companies Act. We can also categorize them by convertibility. Convertible debentures offer a pathway to equity ownership later on, while non-convertibles are strictly debt instruments. If a company wants to issue the convertible kind, they actually have to pass a special resolution in a general meeting first. Non-convertibles are just redeemed for cash on their maturity date. So for an investor, it's basically a choice between playing it safe for a guaranteed cash return or betting on the company's future stock price.
All right, moving on to Part 2, the regulatory framework.
There's a really strict division of power governing these instruments. As you can see, it separates the overarching law from the specific market requirements. The Companies Act provides the broad legal strokes. Then the 2014 Companies Rules get into the nitty-gritty of secured assets and strict timelines. Finally, SEBI ensures that public market transactions are fair, transparent, and properly vetted by credit rating agencies before a single dollar changes hands. The Companies Act of 2013 is really the ultimate legal bedrock here. It dictates fundamental rules, like that total ban on voting rights we talked about, and the strict mandate for issuing certificates. It explicitly states that a company must redeem debentures and pay interest precisely according to the initial terms. Basically, it leaves absolutely zero wiggle room for a company to just change its mind about paying its creditors.
Meanwhile, SEBI steps in as the active market watchdog. They enforce strict rules on minimum subscriptions and mandatory credit ratings. SEBI ensures that before a company even thinks about asking the public for debt capital, they've been independently evaluated. Plus, a company or its promoters cannot have a history of being willful defaulters or being barred from the securities market. It's the ultimate filter to keep bad actors out.
But that brings us to a really critical question. With such massive sums of money at stake, how do these governing bodies actually prevent a company from just walking away from its debts? I mean, rules on paper are one thing, right? But when millions of dollars are borrowed, you need a tangible financial guarantee.
And that leads us to Part 3, Investor Protection Mechanisms. The absolute most crucial safety net here is the Debenture Redemption Reserve, or DRR. This is a legally required vault of money created out of company profits specifically to pay back lenders. By forcing companies to create this reserve out of money that would otherwise go to shareholders as dividends, the law ensures a company can't just drain its cash and leave its debt obligations unfunded.
Let's talk numbers. Companies have to maintain at least 25% of the value of outstanding debentures in this reserve. But it gets even stricter. They also have to invest or deposit at least 15% of the amount of debentures maturing that specific year by April 30th. This creates a hard, undeniable liquidity buffer exactly when the repayment is due. You can't just promise the cash is there. You actually have to lock it away.
Next up, we have the debenture trustee. Think of them as the guard dogs for the lenders. This is a dedicated institution whose single job is to aggressively protect the lender's interests and hold the company accountable. If the company misses an interest payment or fails to repay the principal, these trustees have the legal teeth to march right up to the National Company Law Tribunal, the NCLT, and demand immediate action.
And these trustees aren't just optional. They are mandatory for large or secured issues, and they have to be appointed before any offer letter is even sent out. Whether the company is inviting the general public or pitching to more than 500 of its own members, a trustee has to be in place. All of this is locked in through a legally binding trust deed, which officially conveys the company's assets to the trustee as security.
Regulators also place a strict cap on the timeline of the debt. For standard companies, secured debentures must be redeemed within 10 years. You just cannot string lenders along forever. However, there is an exception. Massive infrastructure projects, which naturally take decades to build and actually turn a profit, or specific entities permitted by the RBI, are allowed to push that timeline up to a maximum of 30 years.
Now for our final section, Part 4, the issue procedure.
So how does a company actually execute this whole thing? Under Section 179 of the Companies Act, it starts with the Board of Directors passing resolutions to authorize the issue. But before they can go any further, they have to secure an independent credit rating to prove their financial health. On top of that, they usually lock in underwriting agreements to guarantee that the issue will be fully funded.
Once the investors actually subscribe and hand over their money, the clock starts ticking immediately. The company has the cash, sure, but the transaction is in legal limbo. The debt isn't legally finalized until a rapid sequence of official documentation and registry updates are executed, proving beyond the shadow of a doubt who is owed what.
And the timeline here is super unforgiving. First, the board formally approves the allotment. Then, the company secretary has exactly 7 days to ensure the investor's details are entered into the register of debenture holders. Following that, the physical or electronic certificates have to be delivered within a strict 6-month window. Missing any of these deadlines instantly triggers regulatory penalties.
Ultimately, issuing debentures is a highly regulated balancing act between a company's real need for capital and the mandatory mechanisms ensuring investor safety. By forcing companies to build cash reserves, appoint independent trustees, and stick to strict timelines, the financial markets are able to maintain trust and stability. It ensures growth doesn't happen at the unchecked expense of lenders.
But before we wrap up, consider this. When the absolute worst-case scenario hits and those safety nets completely break, what happens to the market? Even with cash reserves and powerful trustees ready to liquidate assets, a total corporate collapse can still leave creditors scrambling. It is a pretty powerful reminder that while regulations can perfectly structure a loan on paper, they can never entirely eliminate the inherent risks of the business world. Thanks for joining me for this explainer, and keep questioning the mechanics behind markets.